Thank you, Chair. Gentlemen, thank you for your service and thank you for your attendance here today. Mr. Campbell, thank you. I represent the great Toronto riding of York Centre, which is located in the west side of North York. I want to thank the heroes of 31 Division and 32 Division for serving and protecting my constituents. And I want to thank the entire Toronto Police Force for all the remarkable work you do. Mr. Campbell, it seems that almost daily, Torontonians are waking up to hear about another overnight shooting. Almost daily, we hear of gang-related gun violence or targeted shootings on our streets. Now, in 2022, the Liberals passed sentencing reform, Liberal Bill C5, which removed certain mandatory minimum penalties and expanded the availability of conditional sentencing orders. Could you please tell the committee what, if any, effect did the Liberal government's Bill C5 sentencing law had on gang violence in Toronto in the last few years?
I mean, you're seeing people with additional sentences involved in further offenses. And the reality of it is, if someone shoots a firearm in the streets of Toronto, shoots somebody or is committing major levels of violence, carjackings, kicking someone's door into their house to steal their car keys, they're not going to do it if they're in custody. And I think the reality of it is it's swung to protecting the rights of the accused, and we're forgetting about the victims that are in the streets of Toronto. And, you know, I mentioned we have an NDP mayor, Olivia Chow. She's talking about bail reform. I mean, if we're in the city of Toronto and we're talking that she's talking about this, then things have swung, the pendulum swung that we need to do something about it. So I don't pretend to be a lawyer. There's probably lots of lawyers in the room. I don't pretend to be a lawyer and know every single section and what we need to do. We can follow up with everybody on some of our recommendations, but I know this just as a police officer representing 8,600 people. There needs to be some change when we're seeing people out of custody on conditional sentences with ankle bracelets for shootings and murders, only to continue to victimize the citizens of Toronto.
Thank you, Mr. Save. Thank you, Mr. Campbell. To Mr. Save, you spoke about the need to potentially increase sentencing provisions for young offenders. One thing that really stands out in the last few years, is, and particularly within the realm of gang violence, is the prevalence of youth participation. Of course, if a teenager breaks into a vending machine, none of us want them embroiled in a correctional framework. But if a young offender commits a second-degree murder, their custodial sentence under the Youth Courts and Justice Act cannot exceed 4 years. And when you factor pretrial custody time, young offenders convicted of murder are remanded to very little, if any, post-trial custody time. Can you please offer some recommendations with respect to reforming the sentencing provisions of the Youth Criminal Justice Act to help mitigate some of the gun and gang-related violence committed by young offenders?
Well, thankfully, in Canada, we don't see that very often. However, for those situations when we do, I think I'll go back to, we have a rushed system. In order for a file or an accused who's a youth to be considered for trial as an adult, that's challenging on the system that is already overburdened, that has the Jordan Principle to move forward with, and is stretched. So we need to have proper resources allocated to our court system, regardless of the jurisdiction. It doesn't matter if it's Ontario, Quebec, New Brunswick, PEI, Newfoundland, or Nunavut. In order for them to be able to adequately weigh the gravity of the offense, the impact it had on the victims, the impact it's having on the families and the police officers involved, to make that decision to try as an adult, that takes resources. And ultimately, once that decision is made in the proper form, then you'll have sentencing as an adult.
This is a very important point that you made, Mr. Suave, because I believe that the bail reform passed by Liberals, Bill 75, explicitly removed prosecutorial discretion to charge as an adult. And so now our crowns can no longer avail themselves of that possibility. And so do you recommend that we repeal that provision?
I recommend you study it. What the results of that study is, which is why we're here, possibly one solution.
Thank you very much. So the Liberal Bill C-75, which enshrined in the criminal code the so-called principle of restraint, that offenders have to be released at the earliest opportunity under the least onerous conditions. That went into effect a little over 6 years ago. That bill was passed. How soon after that, Mr. Stamatakis, did you start to see the effects of increased bail on less onerous conditions?
Yeah, I don't know if I can. I mean, this was an issue already, and I think the effects arguably were felt immediately, almost immediately, because for all the reasons that we've described, and I don't want to repeat them, but we do, what I would say is we need almost like a bifurcated system where I actually don't have an issue with the principle of restraint or the concept in C-75 when it comes to, a first-time offender with no history. But what we need to do is we need to find a way to treat the violent repeat offender differently.
For sure, but you're saying you can draw a direct line from that provision to these bail problems on the streets that your officers have to deal with.
Well, I think it's a little more complicated than that because we also have an underlying problem in this country with drug addiction, substance abuse. We have a huge problem in this country with a lack of support for people suffering from mental health issues. But in my view, anecdotally, based on feedback from members, experiences that I've had in my own community where I live, there's a correlation.
I'll ask you.
One of the big fails of Liberal Bill C-75 is that it created a diversionary regime for offenses involving failures to comply with court orders. So offenses such as failure to appear or breach of an undertaking and even breach of a bail condition may go unpunished. Basically, Bill C-75 allows the Crown to divert or remove such cases from the docket. Crowns may be too busy, and they may be tempted to let these violations go. Would you agree that this diversionary regime contributed to additional crime and contributes to additional crime? And what message does it send? Does it undermine the administration of justice, in your view?
That's a hard question to answer, especially within your 4 minutes, 5 minutes. But as my colleague Tom spoke to earlier, the trends are not new. We've seen conditional release be on the upswing, especially during my service. And, I'd recommend a couple of witnesses for you. Like Amanda Butler is a fantastic PhD criminologist out of Simon Fraser University. She and retired Chief Doug Lepard did a study for the province of British Columbia about basically random stranger violence in the streets of Vancouver in 2021. What they found, and we are all creatures of habit, was that during the COVID pandemic, JJPs and judges were reticent to deny bail for even the most violent offenses because of overpopulation or the creation of super spreader cells within pretrial custody jails. That trend has continued post-COVID, post-vaccination, because we become creatures of habit. So is it just Bill C-75, or is it societal in nature?
Thank you. I was specifically asking about those type of diversions.